Hello, everyone. Happy Taco Tuesday. What could be better than eating tacos while participating in a free and very educational seminar? Welcome to Tuesday afternoon networking. My name is Coco Tan, your neighbor, your realtor at Keller Williams Realty in the San Francisco Bay Area. Maybe I had the honor of helping you buy or sell a home. If you are thinking about selling or buying, or just not sure, well, what are you waiting for? Give me a call. You don't want to be the person who looks back and say, I wish I did things differently. And that's the entire reason we're all gathered here today, to learn about what could go wrong with a marriage or with the trust and how to prevent that. We'll be discussing many topics, and there are already so many questions about trust and the beneficiaries and the inheritances. So we will try to answer as many as possible. It's never too late to submit your questions. Just as a reminder, this seminar is being recorded. The purpose of the seminar is for us to learn from the experts and take precautions. We're not here to judge anybody, so please do not mention any names or events. With that said, I want to introduce you the two lawyers that we'll be having a conversation with today. Michael Lee is our trust planning attorney, who you will recognize from past seminars. He's the founder of Ray Attorneys, which does many things, including wealth management for high net worth clients. He's also a law professor at Santa Clara University. We're always glad to have Michael on board when talking about living trusts and estate planning. We're also joined by John Perrott, who has been a certified family law specialist for over 10 years. He has over 17 years of experience practicing family law, helping clients through tough issues such as divorce, pre-divorce counseling and planning, premarital agreements, child custody and support, and domestic violence prevention and defense. John, do you want to start us off?
Sure. So,
hi, John. Yeah, how are you?
I'm doing good. It's late in the afternoon.
So thank you for joining us. Yeah. So what's the first thing you want our audience to know?
So what I want the audience to know is that you can never eliminate risk, but you can seriously reduce it if you plan in advance. Okay. And so the first thing to keep in mind is obviously that if you marry the right person, your risks are substantially less. So be selective in who you marry. But the next thing to consider is you should think about possibly getting a prenup, especially if there's some warning flags I'll toss out. If there's a huge disparity in assets between a potential husband and wife, that can be a concerning factor, and your risk that things may go awry is increased. So I would strongly suggest you consider speaking with a competent attorney to get a prenup. However, my understanding of this seminar is that while a few people will be thinking about marrying in the future, and a prenup is a viable option and a great tool and very effective, if you're already married, I'm going to tender some slightly different advice, which is pretty basic legal advice. You want to not put it in writing or get it in writing. So what I mean by that is, if your mother dies or your father passes away and you get that inheritance, you want to think carefully about whether or not to put your spouse's name on the deed. You want to think carefully about whether to commingle those assets. So let's say you get a stock portfolio when a relative passes away. If you keep it in a separate account and you never mingle it with the other accounts, then if something goes awry, you have a really good chance of being able to trace, that's a fancy legal word, trace, that those assets are your separate property and you can potentially keep them. If instead you take those assets and you put them in the joint account and mix everything up, it's going to become extremely expensive and difficult for you to kind of unravel the knot. And so I think those points are kind of the starting point. From the family law end, I mean, in family law, not every marriage ends in divorce. Some people pick the right person and then stay together until they pass on. Divorces, according to Google, are about 45% of marriages. And so you face some risk of that. And so I think you need to be careful. but there's room for optimism. More than half the time, people find their true love and they stay married. So
That's cool. I think you have a few slides if you want to play it right now.
let's say that again.
You have a few slides. Would you like to have them played right
Yeah,
now?
if we could walk through the slides, that was kind of my outline, actually.
Okay, that sounds good. Thank you, John. And now let's have Michael chime in on the trust planning aspect. Hi,
Oh,
Michael.
hello, Coco. It's a pleasure to be here, and it's great to be here with John. And again, like you said, Tuesday, it's always better that I'm here with you networking. It makes my Tuesday more enjoyable than usual. So great. I'm glad to learn and hopefully provide some information. So my role as an estate planning trust attorney is really on the other side. So what we're trying to take a look at for estate trust planning attorneys is that we, let's say, have a marriage or we have a single person, and we're trying to put together a structure in case something should happen and in case something not so good should happen. And these things sometimes occur. We all wear seatbelts in our car. Yesterday I was skiing. That made it very clear that mortality may be around the corner when I tried to learn how to ski. So it's one of those things. So what is good advice for this is, when is the best time to plan is to plan early and to plan before problems occur. And John hit on an interesting point that he was talking about inheritances or things with your parents, this idea of commingling. And this is something that we often talk about for estate planners, is multi-layered, multi-level estates, of thinking about, okay, we have husband and wife, me and my spouse, we think about our estate, and then we have to design our estate if something should happen to either of us, how to take care of each other, and then how to take care of, if we have children, how to take care of those children. But we also have to think about the upper level. What about her parents or my parents or various siblings? What if we receive an inheritance? Maybe we should think of advanced planning for them so that we solve that commingling problem, that asset segregation problem right out of the gate, and I don't receive the check and deposit it into my joint account. So really what we want to think about is, how can we get ahead of issues and custom tailor solutions for people so that we don't have problems. And like just like marriages, the percentage of estates that have problems are a fairly small percentage of estates, but the ones that really avoid problems are ones that thought it through, planned ahead, and avoided problems at the beginning so that it moved predictably. People generally have trouble when they get surprised. When people get surprised, you generally have litigation. So that's the tip off from me. And I think John has some great prepared information for us. I look forward to hearing.
Thank you, Michael. Now, the majority of our seminar today will be devoted to answering questions. Before we get to the audience questions, I want to tell everyone just very quickly about the 10th seminar, Tuesday afternoon networking seminar next week, which will feature former Saratoga Mayor Yan Zhao. She will be talking about the housing element of Saratoga and in general. So what is this? Well, every 8 years, California cities are required to make a general plan for their projected housing needs, including where and when they will be building new residences and what type they will be. In Saratoga alone, over 1,700 new homes are going to be built. So Yan Zhao will be here to give us updates on the housing element, and we'll be discussing how this will impact our community and home values. Also, I would like to thank the volunteers who have been collecting the questions every day. Special thanks to Yaya and Shanshan. If you remember, Yaya is actually a lifestyle and beauty vlogger who works at Meta and who was featured guest at our recent Christmas 10 seminar about investing in Hawaii. Thank you, Yaya and Shanshan, for reaching out to our followers on the social media. So there is actually, they actually have a WeChat blog, right? WeChat blog. So maybe somebody can share, and if anyone want to join their WeChat blog, and you can scan that, and then this is the housing element. So the next one is for the Shanshan and Yaya's WeChat blog. You can check it out. And it's the one that's with Yaya and Shanshan. Here we go. Yeah. So this is so thank you, Yaya and Shanshan, for collecting the information. And of course, on my wall. So there are several QR codes there for our YouTube, WeChat, and WeChat usually most important so that you can get up-to-date announcement for my live streams and my listings, including weekly new off-market listings. So this is the Yaya and Sanshan's own WeChat blog, which will update frequently. You can also scan their code right now showing on screen. If you connect with me, I can also connect you to them. So thank you, Anna. You can remove it. All right. So today we collected over 40 questions already. So we'll try to select the most frequently asked ones and try to keep each response brief, under 1 minute per question if possible. I think the first question is for John. John, will trust and wills made before marriages still be valid after marriage? I guess it's for John and Michael together.
So my expectation is that a trust, if it has the assets put into it, entered into before marriage, will still be valid once someone's married. I'm uncertain whether, because there's a whole bunch of law about your spouse and some rights the spouse has, whether the will may then have some legal issues because you literally said who was going to get everything and you didn't mention your spouse. But I think that for the most part they're valid, but I'm going to actually bump that over. Mike, if there's a marriage in between, is that going to have a significant impact on the will and the trust?
And John, we didn't plan this. This is completely unplanned, but yes. So just as like John's analysis is, will the will or trust be valid? It will still be valid, but the problem is, it's just as John articulates, it's not really going to match reality because you are now married and you've omitted your spouse. And one of the key problems that you're going to run into is that you can only convey things through the will or the trust that are your property. So if you have a will and a trust from when you were 20 years old, and at 21 you marry and you live together until you're 80, and you are trying to convey all of this property away from your spouse, you're going to have a little bit of a mismatch as to is all of what exactly did you own and how is it going to operate. So a classic problem would be if I had a piece of real estate and I had just bought the piece of real estate at 21 years old, and then I'm married and it's in my trust, and then my wife and I live there for the 60 years, and I'm using my community property to pay for it, and she's using her community property to pay for it, and my trust says I'm going to give it to somebody else, we're going to have a problem. That's not going to work because I'm trying to convey the whole house away from her, but she's contributed to it and I contributed to it as well with community property throughout our lifetimes. So the bottom line, simple answer to this is if you have an old estate plan and then you marry, go visit the family law lawyer and the estate planning lawyer to take a look at this because you really need to update it. That's the major life event that renders that plan obsolete.
Great. And Michael, there's a question for you. Can a will be changed or revoked at any time? Will a will and living trust need to be validated by a court?
Yes. So wills and revocable living trusts, like the name revocable, you can change those at any time. They can be revoked or modified at any time. The challenge, though, with both of these things, you have to revoke and modify them appropriately. Otherwise, you end up with Charles Dickens' bleak house problem of many versions all over the place and people fighting over which versions. So you can revoke them and change them, just do it properly. And then second answer here, one major distinction, wills in California are not, if one passes away and I have a will, that does not avoid probate, that causes probate. Because the will has to be admitted to probate, that's the court, and the court has to issue the letters testamentary, the authority document to the will executor. So it goes through probate, it's not free of court, and it's definitely not free of expenses. Expenses, 4% of the first 100,000, 3% of the next 100,000, 2% of the next 800,000 are what attorneys charge to probate a will. Will is somewhat expensive. The trust is the preferable way to go because that is administered free of the court process. You don't use the court process for most revocable trust administrations.
Got it. John, is it necessary to have a lawyer present, to be present for making a postnuptial or prenuptial?
So I'm going to answer that somewhat indirectly. Anything might work in court. Okay, so if two parties sit down and they, without any attorneys present, sign an agreement, it's possible that the court might enforce it. But that's not the answer anyone wants. No one wants an uncertain it might work answer. If you want a prenuptial agreement or postnuptial agreement that actually has a high probability of being enforced by the courts, then you're going to want to have an attorney on both sides, because there's a bunch of legal presumptions that judges go with, that if you have counsel, they're going to presume that you were advised by counsel, and therefore you understood the law when you made the deal, and that makes the deal more likely to be enforced. There may be some exceptions. I'll just give you one example. I don't think you can put anything in a prenuptial agreement that says what you're going to do with the custody of your children, especially if they haven't been born yet. So even with counsel, there are limitations, okay? But if you want a high probability that the prenuptial agreement will be enforced, you better have an attorney on both sides, okay?
Makes sense. Michael, if I pass away and my husband is still alive, how can I guarantee that money will be given to my children and not to my husband?
Well, great. There are a number of ways to do this, and it depends, what money and where. Of course, classic lawyer answer is always, it depends. First thing that one should consider is, if you're going to do this kind of planning, use the estate planning attorney and work with your spouse to make this a process that is built into your revocable trust. Very common for trust is that we have two halves of the trust. So sometimes it's called a qualified terminal interest trust. If I pass away, my side, my half of the community property locks, and my spouse can't convey it to somebody else. Can't my wife can't get a new, fall in love with the pool boy and run off and take all of the property. My half is lightly locked. Her half is her half. She can do what she wants, but my half is lightly locked. That's very true for real property. It's in a revocable living trust and things like that. The only thing, though, that we do have to be careful of is things like retirement plans. Retirement plans would be a classic one. If I have a 401k that I've had, or any other ERISA plan, usually the IRS numbered plans, I can't just talk to my HR and say, I don't want to put my wife on it. Let me put my kids on it. Because when I say that, they're going to say, well, does your wife agree to that? She's got to sign this, because the ERISA program makes the spouse the beneficiary unless they waive. So the bottom line for this is, if one says, okay, I'd like to prefer my children over my spouse, providing one has a reasonably workable marriage, it's something we should work through and balance out, because it's an asset by asset system. And it also is one of the things is that you have to be cautious too, is because if you have too aggressive of a plan to give assets to one's children, you can sometimes cause undue, more hardship to your spouse than maybe you wanted. So it's something that one would analyze.
Great advice, yeah. Jumping back and forth a little bit for John, going back to your postnuptial and prenuptial, any advice for someone who thinks their partner will be reluctant to sign a prenuptial or postnuptial agreement?
So you can't force someone to sign the agreement. So getting them to agree is probably an order of magnitude more difficult at times than you might think. What I have seen work is sometimes people, like I read a prenup recently, he put a giant carrot in there such that if things broke apart, the other party would get go-away money. In that instance, I can't name names, it was $50,000. And so that was a sufficient carrot for her to then sign off and say, okay, the 3 parcels of real property you owned before marriage, I agree that I won't dispute that if we get a divorce, you'll keep them. That trick probably works often, but I'm not sure I can guarantee that it always works. And people are individuals. And so if you go to one person and say, look, this is really fair, the prenup is totally fair, you keep your stuff, I keep my stuff, it's fair, that might totally fly. If you go to another person, they might want to be unfair. So I'm not sure that I know. I mean, that's one of those, as Mike said, it depends. Well, it depends on the personality of who you're dealing with. I'm sorry, but that might not even be a legal question. That's more of a psychology question.
All right. Okay, for Michael, I don't have many friends in the US, so I put the bank as a trustee. But I heard that if the bank manages the trust, the bank will charge a very high fee. So how much percentage of the total asset is normal for the fees? And does it make sense to do it at all to avoid paying to the 5% probate fee if the bank fee is so high?
This is a great question. And I get this question fairly frequently, not just for international families, but even for domestic families for this situation of saying, well, maybe my children, a lot of times what we're thinking about for the trustees, we're saying, okay, if I go, do I trust my spouse enough to be the sole trustee? And then if my spouse goes, a lot of people then say, okay, my kids will be the trustees. But that's not always the best thought. Sometimes if I go, let's say I want to give half of my estate to my children, I probably need to think about whether I'm going to name my spouse, because my spouse would be the fox guarding the hen house. Maybe I would want to do something else. And the same way, if both of us were to pass, would we want the kids? Maybe the kids are too young. Maybe I have some concerns about their spouses. Maybe they're imprudent, etc. So the bottom line is this: is that choosing a professional trustee is very good, very useful. But I have some qualms about choosing a bank. Why? I have generally found the bank fees to be very high. They're generally on the order of 1% to 1.5% of the trust assets charged annually. So the trust will deplete fairly quickly. They also, that's just the trustee's fee. Anytime they hire an accountant, a lawyer, a manager, that's charged separately. So their lawyers charge separately, their accountants charge separately, their managers charge separately, plus they charge 1% just to sit there, quite expensive. What a lot of people consider is instead hiring a private fiduciary. There are private trustees. There are people who are licensed that can be a trustee. They hire that person. And those fees are generally much more competitive. Sometimes people will also hire an accounting firm or their lawyer as the law firm can also sometimes serve as the trustee. And the fees generally are much cheaper than that of the bank.
Sounds good. We have several questions for both John and Michael. Let's take a quick break and have John present your slides. So John, you can give us a quick overview of your topics one more time, if you don't mind.
Are you
Go
seeing?
ahead, take it over, John. Yeah.
Okay. Okay, so second slide is just some information about me, and then okay, so just a little statistic here, 45% of marriages do end in divorce, so you want to be careful. Prenuptial or a postnuptial agreement are in fact some of the more commonly used tools. The prenup is going to be more effective and easier to do exactly because you don't owe what are called fiduciary duties to someone until you marry them. And so it's easier to cut kind of a hard deal and say, it doesn't matter how unreasonable it is, I'm keeping what I brought into the marriage. A postnup is going to be more work. You're going to have to do disclosures and you're going to have to be more careful in how you draft it because you owe fiduciary duties. And on my slide, I have keeping separate assets separate. That's actually, and we moved, okay, move there. That's, I think I mentioned that earlier very briefly. When you get that inheritance, or if before you marry, here's an idea to consider. This is almost the poor man's prenup. The month before you marry that person, open a new bank account and take all your wages and put it in the new bank account. And whatever money and whatever stocks you had from before the marriage, keep them in a separate account and literally never put anything else in there. And then at least if for the first couple of years or the first 20 years, I don't know, something goes awry, you can trace, that is show, that was your premarital assets. It's not that hard to open a fresh bank account and start depositing your wages somewhere else. I would also comment on keeping good records. In family court, very often the fight is over whether the assets are separate or community. If you can trace, again, that's show in accounting, show where the money came from. If you can trace that it's your separate assets, you're going to be able to prevail. If you can't, then in family court, there's a community property presumption. And the presumption says, we'll presume that the assets are community property and they get split 50-50. So the headache for those who can't trace is you might know that you came into the marriage with, let's say, $300,000 in your stock brokerage account. And then you traded it and added a few more shares when you were working, and 8 years later, divorce time comes. And if you don't have the records, the entire account gets split 50-50. You get no credit for the fact that you brought in the 300 grand. So keeping good records can be very valuable, and I would suggest that you do that. Now, in a marital agreement, you can define what's separate and community, reducing the risk. As I said, there are some things you can't do. You can't define child custody visitation. And you can't include a penalty clause. I think I've lost count of the number of times people have come and they want to put in a clause that says, oh, if he cheats on me, I want, and some say $1 million and some say a couple $100,000, but they want a penalty clause. A premarital agreement is a contract, and it's largely governed by contract law. And in California, you can't include a penalty, so you can't have something that punishes someone if they do something bad. Separate property doesn't immediately become community. And so again, if you keep good records or keep it separate, you may be able to keep it. It comes down to the evidence. So again, my advanced advice is keep good records. Let's see, am I to the end of my slides? No. And actually, I was going to suggest that there's a crossover here, and Michael can comment on that. One really great way to be able to prove that something is your separate property is if it's literally titled in a way that says it's your separate property. And so it's my opinion as a family law attorney that a trust might be a great thing, and it might serve a secondary purpose of saying, yes, see, this piece of property is the Joe Schmo trust, and I put it in before I married, and it's in the trust and it's titled in the trust. That can be a very effective form of proof. So if you're going to get married, you might consider getting that trust done a couple months before you're married. And I think Michael can be more specific about the mechanics of that, but I can certainly see how having a good document which shows what's separate and community can be extremely helpful.
Just to chime in, yeah, with John, works great. Yeah, so just to kind of piggyback off of what John mentioned, that strategy is a very good strategy, providing you do what John said in the beginning, is you keep records and you stick to your plan. So this works very well if I'm about to get married and I have this rental house that I let's say my parents bought for me. My wife and I were not going to move in there. Before I get married, I do my revocable living trust. That has a separate renter. It has a separate bank account. It has separate everything. That stays separate. And it also works in some ways is where I say, well, maybe that rental house also in terms of if I pass away, that really needs to go back to my parents. They paid for that. That was my initial college house. That's really their thing to take care of them. And then I'm totally willing at the same time with my wife to build our community assets, and I'll do another trust. I'll do a husband and wife trust, and that will have the family home, that will have my wages, that will have everything. But that other thing, the Mike Lee single trust, that's my old single life. And the key thing to make it work is, of course, the titling helps, but I also live by the rules. I walk the walk and I talk the talk. I don't realize, the renter skipped out. Community, I'm going to start taking some money out of the community and start paying it into my rental house. I don't do that. I have to be very careful not to do that. But if I keep them separate and I maintain separateness, I'll be just fine. It's the classic one, though, is that the renter skips out and the mortgage is on the rental and the property tax is due and the HOA gave me an assessment because the roof is leaky. And then all of a sudden I say, community, and I start taking out. Then we've got a problem. But if I keep it separate and I do it the way that I was following my plan, we should be, reasonably all right.
Hey, Michael, so if there's still a mortgage on the house and after the grantor dies, the other grantor married again and use the common income to pay the remaining mortgage, how does that count into the trust, and will the whole house value be given to the children?
So this is where this can get actually a little bit complicated, but I'd say the basics is this. The good thing, and this got fixed in the 1960s, is that we have a federal law called the Garn-Saint-Germain Act that says when a person dies and there's an inheritance of the house, the death of the person doesn't cause the mortgage to be due. So the mortgage is not due when the person dies. The heirs, surviving spouse, or the children can just keep paying as they were. So that's good. The problem that then can happen, and this is where one has to really think this through, is if it is a family home with a mortgage, is that is going to cause, for the periods of, post-death payments, if all of the payments are being made by the surviving spouse, that's going to cause an interest of them to develop into the house. It's unavoidable unless, if it's given to the children, they begin kicking in half the share. So this is a classic thing that I hear, just like John was mentioning about things that people wanting a penalty in a prenuptial agreement. I hear all the time of people say, oh, I want my half of the house to go to the kids. They say, well, okay, but let's just think about that. Are the kids, are they able to support the mortgage? Well, they're 2 and 6. They're probably not going to be able to fund half of the mortgage. Silicon Valley's a land of opportunity, but I don't know any 2-year-olds that are making that kind of money. It's not realistic. So that's, again, one of the things we're thinking about. We can allocate the husband and wife shares in a way that maybe is more workable. So what do I do to solve this problem? Maybe we let the primary residence, the family home, go to the surviving spouse, and we balance out with other assets, more liquid assets that aren't earmarked for the kids, or something like that doesn't cause this issue of how do we support a property with a mortgage.
Cool. So John, how do you have a will to give a child part of asset after the remarriage and don't get interference from the other side?
So I think I need to know more. For instance, if you're drafting a will and it's clearly your own separate property, I'm not sure that there's a real barrier there. But if you're trying to leave community property, I think if you were to die in probate court, the spouse is going to have some interest. And so are you asking, the question, how do you do it? The easiest way is that would be a postnuptial agreement. You'd have to actually go to your spouse and say, hey, I have this plan. I want to leave this to our kids. And anything can be done if the other party signs and agrees in front of a notary, but you may have to have that other party actually hire separate counsel in order to make it work. Because if you just get an agreement and there's no attorney on the other side and no understanding of the agreement, then what happens if someone changes their mind? And in family court, there's this presumption of undue influence. It's a legal presumption that one party put emotional pressure on the other and kind of sort of forced them. It's not duress, which is a gun to your head, but it's kind of the soft pressure. And so the court can undo deals that are made during the marriage if one party is benefited and the other party is detrimented. So that's, maybe I gave you too much answer.
And that's good information. So Michael, so speaking of that, how is the trust executed and is it guaranteed to be successfully executed? What are the circumstances that can be hindering the execution?
I'm going to jump on to a little bit of what John was talking about and merge into this trust execution question, is that this idea of, let's say we're husband and wife, and we would like to angle more of my assets to my children rather than the surviving spouse. This can be accomplished in some ways with a revocable living trust with a good design. So a lot of trusts will generally do something like this, that they will have the husband share, wife share. So we have both of those. And we'll say, well, if I pass away, my share is lightly locked. My wife can have income for all of her lifetime. She can have all of the income from the share, i.e. live in the family house. She can do all of these things. But the principal, she can only access my principal if she has no other resources or if an independent trustee allows it. And then ultimately, once it's her time, it drops down to the kids. Very common. That's called a qualified terminable interest trust. Very, very common. A clever thing that a lot of people do is this, and this can generally be done. There's some controversy about it, but it can generally be deployed. As I say, what if I have this? I have the situation where I said that same thing, husband and wife trust. I say, well, what if I start out with, if I go and my wife doesn't remarry, it's fairly lightly locked. She can have unlimited principal, or I'm sorry, unlimited income, and she can have discretionary principal as an independent trustee allows. But if she remarries, then we're going to lock down the principal. She's not going to get any principal at that time. Of course, that could be gamed. I just don't, my wife, she doesn't want to marry the pool boy. She just wants to, play around. Then I'm kind of stuck and it's not going to work. But there are methods to take care of my half. That was my separate property and my community property half, where I can allow some for the surviving spouse and then have some triggers that lock it more down for my children.
All right. So can you also talk a little bit more about AB trust? Is it effective to prevent the husband from using assets after the wife dies? Does an AB trust require additional tax or have additional expenses?
So this is a great question. And this is actually what I was alluding to in the answer before of the AB trust. One thing at the outset, the AB trust, the classic AB trust, is a pre-2013 structure due to the estate tax. So if anybody with us today has a trust older than 2013, come talk to me, because it may cause a problem that you're not expecting in the way that it works if one spouse passes away. The original AB trust was not designed to monitor the other spouse. It was designed to successfully use the deceased spouse's estate tax exemption. So the tool, the design that the clever lawyers and accountants were thinking of was not to pen in my spouse, it was to avoid the tax. So while that is true, it has the effect of tying up one of the shares so that the other spouse can't dispose of the principal easily. So the substantive effect of the AB trust is it limits the surviving spouse from giving the principal to the pool boy. What is the modern way to do it? The post-2013 way is that it's similar to the AB trust, but we have a more sophisticated method where the locking principle is not tied, is not as automatic. It's triggered by certain events, or it's designed in a way that is less rigid than the classic AB system, because the old classic AB system was really to solve a tax problem, not a spousal monitoring issue. So to do a system of spousal monitoring, we have ways to do it. It looks like the AB trust, but it's not the AB trust. So if you look at your 2005 AB trust and say, perfect, I've got what I want. No, you probably have something that's going to act weirdly because it's trying to match a tax law that doesn't exist anymore. That doesn't look like it did in 2005. So it's there are techniques, but there are better techniques now.
Got it. If both the husband and wife have a green card, what's the difference on the trust execution compared to the situation that both sides are U.S. citizenship?
Oh, I'll feel this that we're getting at here is a tax issue. This is an estate tax issue. If you are an international family, you really have to review the issue of the estate tax. So the issue is basically this: is in the United States, the federal national government, when someone passes away, we charge a tax on their net assets. For US citizens, it's really no problem for many people, not everybody in the Valley. Right now, the exemption is $12,600,000 per person. So husband and wife, we've got north of 24 million. So we're clear. Caveat, it's going to go down automatically by statute December 31st, 2025 to about 5 million per person, adjusted for inflation about 6. So, okay, a married couple, we're about 12 million. Okay, you're less than 12 million. You don't have to think about it, no problem. The problem is this: that is true for US citizens, and it is true for US domiciliaries. If you are a non-citizen, non-resident, you're a foreign person, the estate tax exemption for US assets is $60,000. So if my wife resides in Singapore mainly, and she does that because she has maybe high income taxes, and she's a non-citizen, non-resident, if she owns half of the things here and she passes away, they basically take the answer to the question of with green card holders. Green card holders are complex because sometimes you're treated like the non-citizen, non-resident. Sometimes you're treated like an American citizen. So it's going to depend on what you do. And there are two tax court cases, which I always like to mention. One is Kahn and one is Van Hoven. And the tax court comes out in favor of the taxpayer in both cases, but the logic is completely the opposite. Kahn went to Pakistan because he was sick, lost his green card, died in Pakistan. He said, oh, I always wanted to come back to America, but I was too sick and I died there. Tax court says, oh, he was American, even though he died in Pakistan and he lost his green card. He's American. He wanted to come back. And then Van Hoven, he was U.S. green card holder, dies in America, hadn't been back to the Netherlands for years and years and years. He said, oh, no, I wanted to go back to the Netherlands, but the Nazis had invaded and then everything was destroyed. And I didn't want to go back until things had settled down, but I really wanted to go back. And they say, yeah, Van Hoven was really Dutch. He wasn't American. So the logic, it goes two different ways. So the basics of this green card idea is that if you have an international family, especially for that situation, you would want to consider the revocable living trust to address this tax issue, because there's a number of techniques where we can just basically sidestep the whole thing. So do that. Otherwise, if one passes with no trust, no will, you could have a very, very big surprise.
Speaking of taxes, we should have a CPA online, huh?
I know. Well, I tune in all the time. I'm sure we're going to have one. So
Exactly. Yeah, speaking of that, is there any difference for tax reporting between normal living trust and irrevocable trust? Because a lot of audience also wanting to find out how to set an irrevocable trust. Is it higher tax rate, one way or the other?
Yes. So first one's the easy one. If you have a revocable living trust, the usual estate planning, family living trust, no tax reporting. It's entirely tax neutral. You just do your ordinary thing, and it only springs up in case something should happen to you. Contrast this with an irrevocable trust. An irrevocable trust is a tax reporting entity as soon as it's created. So I always use this metaphor for the irrevocable trust. Irrevocable trusts are fantastic, and I liken them to having a pet. Irrevocable trust is a lot like having a pet. Pets can enrich our life and make us happy and do all of these things, but I have to feed the pet, I have to take care of the pet, I have to do all of these things. And if I don't do that, the pet gets into trouble, like tearing apart my sofa and making a mess. That's the irrevocable trust. It has to file returns, has to file the Form 1041, 541 every year, and it has to figure out how it's going to deal with its income. If it holds the income in the trust, it pays on the trust tax rates. The trust tax rates are the same as in an individual, but the brackets are different. You get into the highest bracket, $12,400. So again, you're at the 37% bracket at $12,000. You're paying a terrible rate because the bracket is shifted lower. So you have to be careful. Or you disperse income to the beneficiaries every year, but it's going to depend the tax brackets of the beneficiaries. Or, big problem, what if they're minors? If they're minors, you're going to have a problem that either it's going to flow back to the parents or you're going to have some weirdness. So irrevocable trusts work very well, but you really have to be careful on how you deploy them because they can, just like saying, oh, I like greyhounds. I want to have a greyhound. Greyhound can be a great pet, but you got to make sure that you're ready to have one of those because it takes a lot of maintenance.
Got it. All right. So John, going back to you, if a living trust, I guess for both John and also Michael, if a living trust is established after divorce, is there, and then if there's a remarriage, how to protect the assets and make sure the assets will be given to the children?
I'm thinking that if you are post-judgment, then there's going to be a judgment that defines with regards to the prior spouse who got what. So that's your separate property. And your living trust obviously is going to create proof that it was your separate property. I would suggest, though, if you're going into the new marriage, kind of a belt and suspenders approach, that you should seriously consider having a prenup done as well. And the prenup, of course, is going to have a list of what you had, and it will list all the things that are in your trust to go to your children. So, I mean, having two layers of proof that this goes to the children instead is better than one. That would be my suggestion if you're in that in-between zone. if you could have that ability. So that's a good question. Sometimes people get married the second time. If possible, really basic legal advice, get it in writing. Okay.
Great. So how does California explain the inheritance to the ones who live together but not married?
Oh, this one is quite hard. In this situation, you can end up with some fairly unusual situations here. First thing is that California marriage system, we do not have common law marriage. We don't have customary marriage. We don't have anything that is sort of automatic partnership amongst people. So at the outset, just because I arrange my affairs and live with someone, that does not mean we are married in California and does not confer rights upon each other. Funny story actually about this. Law school roommate, he invited me to what he said was his commitment ceremony with his partner, and it was in the state of Iowa. So we went out there in the state of Iowa, and they were throwing this big commitment ceremony that looked like a lot like a marriage, and we're having this commitment ceremony and all of this, and I use these words commitment ceremony. They generally used invitations as things that said wedding, said marriage, and all of these things. And I joked with him, and I said, you're in Iowa. Did you take a look? You're a lawyer. Iowa has common law marriage. If we go here and we pop a champagne bottle and you say, I'm marrying this gal down on the farm in Iowa City, you're married. Iowa will consider that a marriage. So you say, oh, but I didn't get a certificate. There was no judge or anything. You say, you threw a ceremony and you held her like your wife. That can, Iowa can have some strange results on that. California, we don't have that. So for the estate planning, if you have a partner and you decide that you are not going to marry and you want to provide for this person from your estate, you need to manually do it. You need to do it with your trust planning, with will planning. Critically, healthcare directives. If I want the person I've been with for years and years to be the person making healthcare decisions, I need to state that, because otherwise they will be a stranger to me under the ordinary law. And if I'm incapacitated or I pass away, the law is not going to give a share to the person, even though maybe I live with them for 20 years. It's going to try to pull it away. And if I, presumably, if I don't have children, it's going to put it, up to my parents. If my parents are there, to my siblings. If no siblings, it's going to go to my uncles and aunts, then to my cousins. It's going to get a little bit odd. And I think John, I bet, has a lot on this too, because this, the rights and things about people who are not married, it is complicated.
And if I just may add on that, one of the most common things I see is unmarried persons come to me and ask me, well, what can I do? I've been living with so-and-so for the past 12 years. One of the most common scenarios I see is, I call one person the shark. The shark gets the fish or the minnow to move in and gets the fish or the minnow to pay for groceries and utility bills, but they cleverly always make the mortgage payments from their own paycheck, and they do not ever put the other party's name on the property. So you know what happens at the end of that? If you have 3 kids with the shark, you can probably go to court and ask for child support, and there's no spousal support, there's no property rights. There might be an incredibly difficult to prove a Marvin action if the other person actually made you specific promises and you can prove them, which by the way is very difficult. Okay, then you have a small possibility of getting a recovery that's much smaller than you would have gotten if you were just married. And so if you live with someone for 10 years and have children by them, you're getting yourself into a really bad situation. I'm sorry. Marriage gives you certain legal rights, the presumption of community property, the possibility that if your income is different, you could ask for spousal support, legal presumptions that the children are in fact the children of the marriage and you're both mother and father. There are a bunch of legal presumptions that come when you're married, and they don't apply if you're not married. And so it can be a little bit wild and woolly. And if you thought that that was your true love and you've been paying all these expenses and you discover that he's decided to kick you out and you have no claim to anything, it can be very hard to fix that. And by hard, I mean probably impossible. With maybe we can pick up a few pennies in child support, but otherwise, I'm sorry. So you need to be wise.
It is, it's very hard. We see on the planning side, we see this too, is that because you are each separate individuals, the actual titling ownership really matters. And you end up with all kinds of problems where automatic things aren't automatic. Like I mentioned, the healthcare directive, person, runs into the hospital. This is my significant other is injured. I want to get information. And they're gonna say, who are you? They say, well, I'm the partner. And I say, no, you're not. I'm not. HIPAA and SEMA are gonna, subject me to a lawsuit if I start telling you things. I'm not telling you anything. There's a problem. The other thing is a consideration of taxes. If there is no marital community, you're going to, and you own things jointly, you're only going to have a step up in basis on the deceased spouse's half, not the living spouse's half, because the double step up in basis only is for the total community. So if you have the house that you've lived in together, but you're not married and it's joint tenants, or it's just tenants in common, the first person passes, okay, that's stepped up. But then if I want to sell it, my half, I'm going to pay the capital gains on it. Less maybe if the homeowner's exclusion, but it's just you're gonna operate in a way that is very manual, and unless you really think it through constantly, potentially very unpredictable.
Great point. Yeah. We actually have over 40 questions. We're about halfway through. We have about 10 minutes left. Okay, let's speed up. How will divorce influence an irrevocable trust? Is there a possibility, if there's already a possibility of divorce, what do we need to consider when setting up an irrevocable trust?
This one has to be very careful with an irrevocable trust and the stage at which one's setting it up. If we're married, and I am setting up this irrevocable trust, and we're setting it up with certain beneficiaries that don't include the spouse, we really have to design, are both persons setting it up? If we're both setting it up, and we're both setting it up by agreement, and we're saying, okay, husband's going to agree to lock up the assets and he's going to contribute and wife's going to contribute together, then maybe we're okay. And then maybe if there's a divorce, the irrevocable trust will stay standing. But we have a big problem, and John will probably, he'll go into how I can get into a lot of trouble if I say, I'm actually, I saw my wife making eyes with the pool boy. I am suspicious. So I'm going to start skimming. I'm going to, tell my attorney to create an irrevocable trust. I'm going to start skimming out of the marital community, and I'm going to start locking up my share secretly. I'm going to lock up. And then if something happens, I basically, I've kind of taken care of myself. As John will say, I'm going to be in for a world of problems when I do that.
So what I'll say is Mike's correct if you get caught. And so here's their fiduciary duties under Family Code 721B, and the language is neither party shall take any unfair advantage of the other. You're married, you owe fiduciary duties. In the event that a breach of fiduciary duties is shown, it actually has to be shown, then under Family Code 1101G, the court can award 50% of the community property hidden plus all attorney's fees incurred, okay? Now, in rare situations, family court attorneys always hope they can get that Rossi sanction on the other side. There's this case in remarriage of Rossi where the parties were still married. Wife bought a lottery ticket. It was a winner. She lied and told husband, no, I have nothing. She signed her preliminary declarations of disclosure, her final declarations of disclosure, a response for demand for production, and she testified in her deposition. It was all straight lies. And then she got caught. And 100% of the remaining value of the $6 million lottery winnings were then awarded to husband because wife had lied. So if you are caught skimming, that is stealing from your spouse, the sanctions could include the 100% in remarriage of Rossi sanction, okay? Now, unfortunately, sometimes people do a little skimming here and there and they don't get caught, which takes me back to the previous advice. You want to keep good records. So if you think you're going to go into divorce, make sure that you get copies of all the recent bank statements. Don't lose copies of the tax returns, because something that I see happen really often is the bad party figures there's going to be a divorce, and then suddenly the file cabinet with all the tax returns and the bank records has been disappeared. And your family law attorney is going to want to have evidence to show the skimming. And if you don't have proof, that could be a problem.
Okay. And then going back to the no penalty clause, this is no penalty clause. How do things like infidelity, alcoholism, or domestic violence factor into dividing the assets?
So in a contract, you can't include a penalty clause. It is the case that there's a body of law regarding fiduciary duties. If you can successfully prove, that's your problem, you got to prove it, that something was not for the benefit of the community. I'll use a harsh example. Let's say husband goes out to the strip bar and he's putting $5 bills into G-strings and he's having a party, right? And wife wasn't there, and wife is very unhappy about it. And then let's say husband then buys an $80,000 sports car and gives it to his girlfriend, and wife is extremely unhappy about it. Well, if you prove those things, then the fiduciary duty statutes say, again, that's not for the benefit of the community, and that comes out of husband's share, okay? You do not get a specific dollar recovery for the emotional pain, for the feeling of betrayal. You have to tie it to the dollars that are taken. But if you had all the proof, if you had a photograph of husband sitting down there with his girlfriend at the restaurant, you could potentially say, if it's a $100 a plate restaurant, you could have a claim for the $100 spent on girlfriend. You could present that. You could potentially get a recovery. That's the family court does that. It's not a contract-based thing. And it's not technically a penalty. It's just recovering what's fair.
Got it. What happens to the property bought before marriage but still has mortgage payments after marriage? Does that become to be community property?
Sort of. So there's these cases more in Marsden. And so let's say you had a property you purchased before marriage, and then during the marriage, you continue to make mortgage payments. There's going to be a math calculation based on how much the principal pay down of the mortgage using community property funds were. My recollection is it's the specific number of dollars the principal's paid down. And then there's a second dip, which is the percentage of the original purchase price and that portion of the appreciation. So if you have a comparatively short marriage and then you're out, the more Marsden claim can be fairly small. If it's a really long period of time, the more Marsden claim can become quite large. It depends on how much the mortgage is paid down.
Gotcha. So what is the best practice to allocate the assets to the children? Should they get all at year 18, right? Age 18, or get portions of it as they get older? If they receive the remainder, for example, at 35, does the child become to be the trustee when they are 35?
Well, this is a great question, and this is something that modern estate planning has really solved. And I usually introduce what one should do with a story that I have. This is really not thinking as the lawyer. This is really thinking more as counselor, parent, family member. And it was a case that I had that was not a traditional estate administration case. It was a conservatorship case. It was kind of like a Britney Spears case. We had a young man. He was 19. He was the only child. Tragically, the parents were killed in an automobile accident. He was the beneficiary of two $10 million life insurance policies. His parents were both high-up execs in the tech industry, and he was 19 years old. And Allianz and New York Life said, "Where do we send the $10 million check?" Problem, because when you have grief and money, that's not a good combination, because you use the money to try to deal with the grief. And there's a famous story for the young man. He went down to Los Gatos Fine Cars down there where they sell the Ferraris. They went in there and said, "I want a Ferrari." And of course, he's a 19-year-old guy, and they say, "Get the heck out of here! We sell real cars here. No Ferrari for you." And he types into on the banking app, says, "Got $20 million. I want two Ferraris." And of course, "How may I help you, sir?" And he buys two Ferraris. Story of the guy, the $20 million, he only had it about 3.5 years, and he had lost about $7 million, and he bought no real estate. So can you think about how fast this person was blowing money? So the moral of the story is thinking about the allocation for children. Generally, what works well is thinking through a system to space it out with the child's maturity level. And this dump the assets on them at 18, if something should happen, tends to not work well. Generally, what you want to do is stagger it at ages. And what modern estate planning generally does now is we don't do what are called outright distributions. We don't say, if you're 18, if you're 21, if you're 30, you get 25%. Instead, what we say is at certain ages, a right springs up that if the trust is in administration, the parents have passed away, you get the right to withdraw 25% or 15% or whatever, at age by age, providing you're not under duress, or some other either creditor duress or spouse. And then this way, we put the decision on whether or not to take the money out of the estate into the future in the hands of the beneficiary child, when he or she can think through, before I take this money out of the trust, am I being sued by creditors? Because if I am, maybe I don't take it out. I'll let the spendthrift clause protect it. Or am I potentially going to get married? Maybe I'll just let that stay in the trust and see, and again, avoid this commingling, avoid this mix-up, leave it in the hands of the trustee, and I'll see how the marriage turns out. And then maybe I'll start drawing it out. Be much safer than the old way used to be, where do I send the check? Where do I send the check tends to cause clumsiness and unpredictability. And planners, we don't like anything unpredictable. We like things very predictable.
Got it. There are a bunch of questions regarding this age. So for example, I made a trust before. One of the children was a minor at the time, but now he's adult. Does the trust need to be updated? And also for a trust before the children turn into 18, do we need to assign another guardian other than parents? So you want to quickly address that, Michael?
Yes, two things. If the kids have grown up and you have an outright distribution at 18, if you think they're not ready for it, you might want to amend the trust and do staggered distribution, especially if you say, even if they're older, you say, my child has a lot of problems with his or her spouse. Maybe we want to kind of pen that in now. The second thing is, if you have minor children, you absolutely have to think about nominating guardians for them, because of course, if I'm married and I pass and my spouse is there, very, very difficult to bypass my spouse. My spouse has, very high, almost supreme priority to become the guardian of my children, but for cause. But if we both pass away, we really need guardians nominated to show, that we have an agreement, and to outline how this guardian is nominated. And it is particularly critical for a lot of my international clients. I would probably, a high percentage of my clients have this. Husband and wife are green card holders, permanent residents, or we're a variation of a visa, and my children are U.S. citizens. Then the agreement amongst mom and dad say, well, if something happens to us, we want mom's mother to be the guardian, who's a Chinese citizen and wants to take the kids back to China. You need to really think this through and work this through with your guardian nominations, like the temporary guardians nominated, because Judge MD, Judge MD is in Santa Clara, and then Judge Granster is in San Mateo. Those are not Asian names. They're not going to sort of think about this of the Asian family staying together. They're going to look at the probate code. So you really have to think through of if you have an international family, you have the guardianship consideration is premier of the things that you got to look through.
Okay, very quickly run through this international thing. A few things related to this. If a Chinese citizen who holds a US green card dies and has no will, and most of his personal assets are in the US, and how does he let his parents in China inherit everything? That's one. And second, can a non-green card, non-citizen be named as trustee? That's also like international thing. And one last one is, can the will say that after his or her death, his or her parents in China will bring their grandchildren back to the country to raise the children?
Okay. First thing, non-citizen, non-resident as trustee. Disaster. Don't do that. It becomes a foreign trust. It has the worst taxation you could possibly have. So if you are naming a trustee, you need a US person. Citizen is ideal. For persons who are international persons, you're a green card person, your assets are here, strong recommendation, do the trust. Don't do just the will, because the will has to go through probate and it's very, very cumbersome. So use the trust to accomplish that. Very easy to just box up the assets. If anything happens, your US person trustee gathers them, liquidates them, gives the money to your family. Last one, in a will or guardianship declaration, can I just declare that the children are taken by my mother-in-law back to China? No. I actually saw someone, an attorney on the forums, post something of like, oh, we'll just name a guardian and then there'll just be a private agreement that the guardian will give them over to the in-laws to take back to China. So I wrote back and said, that's a nice way to go to jail. I mean, you're going to go to prison for that. You give children away and then you're charged as a guardian, in the court. And they're going to ask where those kids went. So what's the bottom line? What you have to think about for the international family is the probate court's always going to think about the best interest of the children. And what you really want to do in these situations is express, first of all, potential for temporary guardians, for US persons to be the temporary guardian. So something suddenly happens, we name a temporary guardian, they're a US person, everything's stable. Then for permanent guardianship, maybe we will nominate persons who are non-US persons, and then outline that we're aware of that, and then outline the issues, and then the probate court will at least have some understanding of what the family dynamics were, and then it will be in the discretion of the probate court of what they want to do. But it is very, very tricky and complicated with an international guardianship.
Got it. We are really running out of time. I'm going to take last two questions that's related to parents. So number one, if I'm married, I have no children, can I set up a living trust to my parents in China? Number two, are the assets owned? So their assets we own now consists half of the cash, stocks, and the property owned by husband and wife. Are these basically half of them husband is wife? If so, can the wife or husband unilaterally set a last will to leave his half or her half of the asset to their parents proportionally?
I'll just jump in on the first one for, can I do a revocable living trust and make my parents in China the beneficiary? And I'm assuming if I'm married, I can create a structure similar to this, but we have to think through a couple of things of whether it's advisable to do that. Because let's say we own a family house together, do I want to throw my spouse out of the house and make them sell it to give half to my parents? And maybe I don't want to do that. So there are some ways where we can say, well, which is more common, is we use this qualified terminable interest trust. The principal is earmarked for my parents, or I have certain amounts that are liquid that I give to my parents right away, and then other parts are reserved for my spouse. Things that are clearly, my separate property or my share of the community, we can do that. And then the other thing is, if we have, long-term marriage, we're husband and wife, we have a lot of assets together, can I unilaterally set a will to give half of my assets to parents? Generally, I'd really recommend avoiding the will to do this because of the probate. But you can, your half, when you pass away, your half of the community, you can convey to whomever you'd like. It's just the problem is that this can tear apart your marital community in a way that you may not intend. So this is something that I get a lot of, especially recently, a lot of people asking for this. And really what we do more often than not is that we look at it asset by asset. And we say, well, some assets, maybe family home, Q-tip, we'll reserve that for the surviving spouse, and then other liquid assets we will, providing there's no claim or limited claim from the surviving spouse, we will direct to the parents. So it can be done, but it's one of the things that has to be done carefully with consideration, because just leaving a will, I give it half to my parents, that's going to cause likely consequences that even the person who did it did not intend.
We're completely out of time right now. We have so many unanswered questions. I think we need another seminar for this one. So if you still have the unanswered question, I know a lot of audience still have unanswered questions. I guess you can try to stay here and we'll try to see what we can do to get you an answer. This, however, is our official end of our seminar, and we will stop the recording right now. before you go, make sure you scan the QR code right here, and then so that you can stay up to date for my seminars and listings, and make sure you say thank you to our guests, John and Michael. We have unmuted everyone so that we can allow you to do so. I hope to see you all next week for an update on the housing element featuring the council member and former Saratoga Mayor Yan Zhao. Thank you so much, everyone. Have a great night.
Thanks.
Thank you.
Thank you all.
Thank you.
Thank you.
Feels like we should get another
Thank you.
round of seminar. Thank you. Because there's so many questions. I think I probably gone through 2/3 of them.
Yes.
So, yeah.
Thanks, Michael, and thanks, John. And Shanshan probably will extract more some questions that discuss most and publish it in our blog. So yeah.
Yeah, publishing the blog. Yeah, that's great. So we're going to have this recording available on YouTube, and then we're also going to, that's great. We're going to summarize this and put in the vlog.
May I ask one more question before Michael and John go? What would be the downside on the revocable trust? Will be the pros and cons? It has pros and it must have cons too. So will be the downside.
Well, I would say in California, there are very few downsides to the revocable living trust. The only minor downsides are, of course, like anything, you have to invest a little bit to draft it, and you have to record the deeds for real property. So there's a little bit of an investment there, and you have to think through your distributions to allocate them appropriately. But other than that, it has very few downsides in that it's not a tax reporting entity, so you don't have annual fees there. You don't have annual maintenance fees with a lawyer or anything. Once you set it up, it's established. And the pros, avoiding the California probate fees, which are quite hefty, 4% of the first 100, 3% of the next 100, 2% of the next 800, 1% of the next 9 million. You have $1 million estate, it's $22,000 in attorney's fees. If you have a private administrator, it doubles it because the private administrator charges the same as the attorney. So really the downsides, there are very few in California for doing a revocable living trust, and very substantial benefits.
Got it. Thank you so much. Really appreciate both of your knowledges and advices. It's a great seminar.
Thank you for the question. We really appreciate it.
Thank you so much. Thank you, John. Thank you, Michael.
Thank you, Coco.
Thank you so much. Like I mentioned, probably have to call you back for a second seminar.
This is a hot husband and wife relationship is a hot topic, as John well knows.
Yeah, there's several books that actually husband and wife should read. One of them is about the love languages, and because very often conflicts between are not driven by someone being a bad person, but literally by misunderstanding. And so there's several love languages. And if you figure out what it is that your spouse, how they receive love, like some people, it's quality time. You just spend quality time with them and they're happy, right? Other people, they want gifts. Other people, they want words of affirmation. And so if you figure out kind of what works, you're more likely to hold things together. And obviously the opposite is true as well. If you're trying really, really hard to give gifts and your spouse doesn't really care about gifts, they want words of affirmation, not gifts, you can be making a huge effort and it's just not working. Things fall apart. So you really need to look into that.
Great advice. Thank you.
Mm-hmm.
Wonderful. So thank you everyone again. Look forward to seeing you again this coming Tuesday, next Tuesday. Yeah, March 29th. All right, so have a great evening. This is a very beautiful day today. It's actually hot.
Great.
Yeah.
Well, always a pleasure. And then we look forward to seeing you again soon.
Thank you so much. Okay, have a good night, everyone.
Take care.
Take care. Thank you, John. Thank you, Michael. Yeah, thank you. Bye-bye.